Alrighty, so we will go ahead and get started. Firstly, I want to thank everyone for joining us today, and I hope that you guys are having a good day so far. My name is Ayana, and I am the marketing and media manager here at the Cromeens Law Firm. And today we have Karalynn Cromeens, who is a published author, award-winning lawyer, owner, and seasoned managing partner of the Cromeens Law Firm, and also the Subcontractor Institute, which is an easy access online educational platform for contractors. So in today's webinar, we'll be breaking down the best practices for communicating with your client, ways to adjust your contract, and other essential tactics used for mitigating defective work claims. So before we get started, just a few housekeeping things. I'm asking that everyone keep their computers muted. Microphones muted during the presentation. And we also did provide a handout, a fill in the blank handout in the emails that were sent out. So please refer back to those so that you can follow along here. We'll also be having a Q&A at the end of the presentation. So feel free to submit all the questions that you may have in the chat or unmute yourself at the end. And this is the perfect time to get all your questions answered with a licensed attorney. So be sure to take advantage of that. And I'm going to go ahead and give it away over to Karalynn.
Hello, guys. Thank you for joining us for this lunch break webinar. Very exciting topic, defective work claims. Before we jump into the topic for today, I just wanted to take a minute and tell you a little bit about who I am and why it matters. My name is Karalynn Cromeens. I've been a licensed attorney for the last 17 years. I've dealt with purely construction law, whether it's the collection side, the defect side. But even before that, I was involved in the construction industry, growing up in the industry. My first jobs were for my uncles who were subcontractors. In my last year of law school, my husband and I started a material supply company, which is still in existence today. And so I've gotten really good at understanding how the construction industry works, which is really a benefit when it comes to being a lawyer and then helping my clients in the construction industry and from the legal perspective. With that being said, one of the things that, usually you're not in business very long without somebody making a defect claim or some kind of claim of bad work, and whether it's a valid claim or a claim to avoid payment, it doesn't really matter. The thing is that the claim has been made, right? So defect claims happen in both commercial and residential projects, and we're going to go over some advice for both of those types of projects, which are in some ways the same, but and kind of different in the, a subcontract has way stronger terms than normally a residential contractor would have, but kind of going into the key points that you would need to have in a residential contract to kind of avoid those disputes. And then on the commercial side, what you can do as well. So knowing how to deal with these claims up front. So the first thing is, go to the next slide, please, Miss Ayana. Thank you. I know that dealing with these claims can be a pain in the ass dealing with high maintenance homeowners, pain in the ass dealing with GC sending multiple emails about the same thing. But one thing I can tell you for sure, like anything else in life, if you ignore it, it will just get worse. Don't think by not answering the questions or not dealing with the issue, it's just going to go away. And actually will be way worse than if you didn't respond at all, or if you just ignored it, walk the job, whatever. I promise you what can happen is way worse than just digging in and dealing with it. So that's the first thing. Don't ever ignore it. But here are some steps on what to do if it happens, and what these defective work claims look like. First thing, respond in writing. So most defective work claims come over in writing. Some of them can be verbal, depending on, especially on the residential side, it's more verbal. The homeowner saying that, I don't like your work, it's not complete. And so what I usually, the first point is, okay, let's have a discussion about what the issue is, right? What exactly the homeowner says the issue is, and kind of go through that. And then we respond in writing with, hey, I see your issue. Here's how we're going to resolve it. Or, hey, I see your issue and that's really not my work or something for me to do, and here's why. And we'll go into that more in a second. The thing is we respond in a way very clear and easy to understand. There's no legal words that have to be used to be effective. The main thing is that you've taken the time to address the issue and to respond. So this goes for commercial contractors too, and how you respond. So What's the plan? Respond in writing. When you follow, after the initial meeting, follow up with an email on the plan and how you're going to correct it. This commercial contractors too, I help clients all the time. They get little emails about things that are not being done. Don't ignore those, right? Even if it's, you need to sign this piece of paper you agreed to sign at the beginning of the job. Whatever it is, yeah, okay, yes, I haven't gotten to that yet, but I will. Not responding can lead to termination a lot faster. So make sure you respond to any emails and claims of bad work. Some of the other things that on the residential side that I see that can help you avoid defects claims even from the beginning is having a clearly written scope of work, right? There's no job too small for a contract. And it doesn't have to be a big contract. It can just be, here's my scope of work with some terms and conditions, right? So even if you're in and out in a day and it's a really small job, having a clearly delineated scope of work and terms and conditions is extremely important. You have some examples in your handout, but a lot of the defective work claims, especially on the residential side, from the contractor's perspective, are not things that they were hired to do. Or, if you're doing a kitchen remodel and how your work lines up with the next room was not something that you were hired to do. But if you're clear about that in your contract, they can't come out later on and say, oh, no, you're not done, or your work's defective because it doesn't line up the way it's supposed to, or there's something wrong in the other room. Coming back to the scope of work is hugely important, and saying, hey, no, that wasn't included. It's not defective work claim. You didn't hire me to do that, and just being upfront about it. And then if they made that claim as a defective work or incomplete work, you have the discussion. You followed up with with an email. We had this discussion. Here's what you said, and here's the reasons why I'm not responsible for that. And then if you still don't get paid at that point, we have a discussion about lien rights and other ways to get you paid besides this. So make sure that you have a clearly written scope. Another thing that I highly recommend for my residential contractors is explaining the punch out process, the punch list process before they sign the agreement. It happens, I see it happen over and over again on the residential side, like a homeowner, especially if you're working multiple weeks, they see little things that aren't done or not completed yet, and they're slowly getting agitated, right? I've seen contractors get fired for punch list things. They don't understand that it's not, we're going to polish this up when we're done, it's going to be beautiful. There might be little things that paint touch up or whatever, but we'll get that at the end. So I explain, or have it in my residential contracts, what this process is, what it's for, and then most importantly, have a process that once we do this, you get one time, you get one punch list. I'm going to do that, and then you're going to sign off that you've accepted the project, right? This is how it goes, and so that way they know while they're going through the project, if they have issue, they can take a note of it, right? And we'll talk about it at the end, and there'll be one final walkthrough with one punch list. We don't have multiple punch lists, just one. And then when we do that and we correct those, then payments due. And so stuff like this can definitely help with defective work claims, because if you say, these things are going to happen, we're just not done yet. And them knowing that they will have a chance to give you all the list of little things that they've noticed and you will fix them is very reassuring to them. And because guys, they have no idea how this process works. They're not involved in construction, and and some of the things that can happen if you don't tell them how this works, it can be very detrimental. So I be upfront, put it in your contract, and then take the time to explain it too, because not everybody, as you know, reads contracts. But it is helpful to manage the expectations, especially on the homeowner side. All right, discovering. So this is more on the commercial side, right? So when you are hired, you're given a contract and it has plans and specifications, basically the instructions on how to do the job, right? And these are the type of materials, how installation is going to happen. Everything's already spelled out for you, right? So make sure you review that before you get started, because that's how you're going to be expected to do the work. So just as everything's specified and the specific materials are specified, then you're required to do that work that way. So here's why it's important, because you could go and everything is perfectly correct at the job site, except you didn't install it the right way or you didn't use the right material. And even though it's not defective, like meaning like it doesn't work or it's broken or, you know, it needs to be redone, it is not in accordance with the contract documents, which is technically configured. It's called non-conforming work and still is considered defective work on the commercial side. So, you know, I know a big thing that I see is the specified materials, like the commercial project specs a material that's a higher grade or higher quality than the sub is normally used to using, and they didn't pick that up, right? They didn't realize that, and they put the cheaper material on the wall or on in the project. Somebody finds out, and now it has to all be redone because there was a certain warranty with this level of product that the owner wanted. So this can be a huge thing. It might look beautiful, might be the best thing you've ever done, but if it's not done in accordance with the plans and spec, technically it's defective work. So do realize that you can't just do it the way you want to. You have to do it in accordance with the plans and specs that you've been given. Another thing here that is important, that you know the exact plans and specs, read them before you start the job. Another huge thing that I like to point out here is that if you signed a subcontract that has a set of plans and everything that describes your work, your bid or how you said you were going to do the work is not part of the agreement. So if you thought, I'm going to bid this work this way, they accepted it, and now I signed a subcontract, I'm still going to do the work that was mentioned in my bid, that is not correct. You are now, once you sign that contract, you are now on the hook to do the work as it's described in the plans and specs. And those things may or may not be the same, right? But knowing that before you sign the contract is hugely important, right? Like, as if you bid a lower grade material in your bid, but when you sign the contract, it's got a higher grade material in there, and you don't catch it before you sign the contract, now you're on the hook to do that, you know, or provide that extra grade of material without getting any increased price. So if we notice that this is an issue or this has happened, the difference between the bid and the plans and specs, we need to have it corrected before we sign the contract. Don't rely on any words of, oh, we'll give you a change order later on. The contract that you sign is the contract that will define the agreement, and a promise, a verbal promise, even an email promise to change it at a later date is not going to be enforceable. So big thing, guys, you know, especially if you know, we're doing huge commercial projects that your work may have to all be redone because you didn't do it with the right material or you didn't install it the exact way that they said. So your bid does not become part of it. It's the plans and specs that are attached to the contract that matter. So this is, I represented a masonry contractor who was doing stone work and an exterior of a house. It's the residential side. And, you know, he's going throughout the project, and there are scrapes and scuffs and, you know, gaps in the stone and things that needed to be fixed. Well, the homeowner had enough and fired him. And he's like, wait, I wasn't done yet. But the homeowner did not understand that there was a punch out process and all of these little things that, you know, the gaps where it needed more mortar and stuff like that would be fixed at the end. He fired him and he sued him, and we went to court. And we have 12 jurors who are homeowners, not contractors, and all these contractors see are these big blown up pictures of scuffed paint and gaps between the stones that aren't fixed, and they think that that's horrible, right? And we know that's just a punch list. It's going to be done at the end. He got a judgment against him for a substantial amount, plus he had to pay attorney's fees because it wasn't made clear to the homeowner that I'm not done yet. All of these things will be taken care of. So be upfront about, on the residential side, about the punch process and what that looks like. All right, so getting sued for defective work. We hope that never happens, right? But say you try to resolve it. And I have to say, on the residential side, before you could be sued, there's a whole process that a homeowner has to go through of sending you notice. It's called the RECLA process, which you could, I know I have blog articles on it, that basically they have to give you a chance to fix everything, and you get a chance to make a reasonable offer. If they, you know, you can't, then they can sue you, but they can't sue you without going through that process. If they do, you can stop that whole lawsuit. So something to know there. But if you get sued, We need to obviously try to prevent that with the contract documents, have the sign-off sheet on the walkthrough, and on the commercial side, if there are defects claims, try to prevent that with daily reports, letting the contractor know if there's the GC or owner know if there are issues on the front end. But hopefully, before you get sued, there is a process that negotiations, and in that negotiations and trying to resolve the issue, we really need to take into consideration what being sued or moving forward with a lawsuit would look like, right? Because if we decide that we're not going to offer what they want, we're not going to give them what they want, we know that's going to end in result in a lawsuit. What are the risks of that situation? And is that risk, is it less of a risk to just do the work that they wanted, even if it's not what we think we should have to do? But is it going to cost less to do this or cost less to go to litigation? And that's something, when we're going through this process as an attorney that I'll help walk you through. We're like, all right, if we go down this road of litigation, you're going to pay me thousands of dollars. You're going to have to give me hours of your time in depositions and turning over documents, and really, there's a really high cost to going litigation, where I'd much rather you use that money and that time that you were going to give me to go to court to work on growing your business, right? So yes, it's going to cost you more on the front end to do this correcting that you don't think you need to do, and I probably agree with you. But if it's going to be $5,000 extra as opposed to $30,000 lawsuit, I mean, the numbers talk for themselves, as opposed to the stress and dealing with all of the stuff in the lawsuit. Going a little extra to resolve the issue may be worth it. I'm not saying you have to get it walked all over, but let's at least have the discussion and discuss the pros and cons, the dollar cost, the time cost, and all of that, so you can go in and with an informed decision. The other problem with going to court, either as a residential contractor, it's more of a level playing field if you go to court as a commercial contractor, because it's a contractor versus contractor, or owner versus contractor on a commercial project. But especially for residential contractors, is who is making the decision if you win or lose. Generally speaking, it's a jury, right? And a jury is people of your peers. They're homeowners. They're more homeowners than they ever are contractors. And so even if you did everything right and you filed, but they see somebody's home looks like it's being destroyed, it's really, and they're judging things like credibility, like, who looks better on the stand, who do they, there's a whole bunch of things that you don't think about when you're entering into this dispute that has a huge effect on the outcome of any dispute that you take to court. A part of that is, and even a judge is not versed in the construction industry, how that works. So if your case is being decided by a judge, he's going to evaluate the evidence based on his experience, not the experience of a contractor or anyone in the construction industry. So take that into consideration as well. All right, so if you get an official defect claim, realize, whether that's an email, a letter from an attorney, something written, realize that that will be exhibit A in the other case, in the other side's case, right? That's going to be their first document to be like, hey, I told you about all these issues. And then what was the response, right? Is it a response in writing from you saying, here's yes, here's why, and here's what we're going to fix, or no response, or response of here's why it's not my fault. So you need to respond, because you want an exhibit B that counteracts that exhibit A of here's what really happened, right? And it doesn't have to be through a lawyer, it can be on your own, but definitely have some type of written response. I'm a lawyer, I like everything in writing. If it's not in writing, it didn't happen, doesn't exist, especially when you have a signed contract. So another thing is the paper trail. Here's what I tell my clients: as soon as they get a notice of defect claim, take the time, stop right there, and just internally do a timeline of events. Handwritten is fine, whatever. It's more for your internal, it's more to remind you if we have to go down this trail and it's 3 years from now, 3 years from when it happened. So it'll stay, well, it's fresh in your mind, having the history of how everything happened. Just for you to know, right? And it helps me put my case together if I know exactly how the timeline happened, who, what, where, why. So do an internal timeline and have it for your records. And so then the paper trail along with that, hugely important. So do the timeline. If you disagree with the defective work claim, that timeline becomes very helpful. We put the timeline in an email or in a response letter. Here's why, here's how it happened, and then here's all of my evidence to prove that I'm right, whether that's the contract, whether that's photos, whether that's emails back and forth, whether that's screenshot of text messages of things that went back and forth. Yes, you approved it. No, I put that all together. I mean, and then that's your response, right? That's so most important, because if you don't respond, they think that you disagree with them. So defense against defective work claim, weigh your options, pros and cons. I really think if you're getting an official certified letter, a letter from an attorney, you need to go talk to an attorney about the risks moving forward, how to respond, even if you wanted to do it yourself. But you know, what it will cost to fix what they're saying, what are the potential consequences of not doing that. And so really having an informed decision, and like I said, an informed business decision, not decision made on pride or trying to prove that you're right, because nobody wants those fights. And at the end of the day, guys, when you go to a courtroom, the best you can absolutely hope for is to break even. And 99% of the times that doesn't happen. And that's just monetarily, that doesn't account for your time for dealing with it, the lawsuit, and having to, and the stress that it puts on your life. So make sure you weigh those options as well. On the commercial side, when you sign a commercial contract, and most commercial subcontracts, there is a provision that says, just generally across the board, that once you get on site to do your work, you have a duty to inspect all of the work before you, and you need to point out in writing all of the defective work that's there. If you don't do that, then all of that defective work, when you put your work on top, now becomes your defective work. And so that's when you see when all those people get sued, and you know, when a property owner sues all of the contractors, that's how that happens, is that they stack on top of each other. If it was defective, like defective concrete, then everybody from there on up has accepted that, right? And it just kind of all collapses and everybody gets added. That, and because all of those people have insurance that'll cover a claim, and it's a way bigger pot if everybody's involved. But that's how you need to, so realize if there's defective work before you start, you need to point that out in writing and make sure they correct it depending on the terms of the contract before you start. If not, then it becomes your defective work, right? And so make sure that if there's something before you that's going to make your work defective, that you point that out and read what your contract says about how to do that properly. Another thing that is in most subcontracts as defective work claim, this comes up as defective work claims, is protecting your work after you leave the job, but before the project's done, right? So I've had this happen to several clients. I had a eaves contractor in a hotel downtown San Antonio that after he left the job, some other sub scuffed up the work and they wouldn't pay him because he had to come back and fix that, because in his contract it said he had a duty to protect his work after he left. If not, it was defective work. Also had it happen to a window contractor who installed the windows, and then somebody else bumped them and got them all off center, and they had to go back and fix it at no cost to them because they had this duty to protect their work. So know that that's in there. Know that if you want to change it, don't be wrong, you don't get charged. You can't, you know, get a change order for the extra work to correct it, but you could go after the sub who actually caused the damage to the work if you wanted to. It's just not going to come from the person that hired you because of this protection after your work that's required by the contract. So make sure you know that's another way that defective work claims can be made, even when you're done with the job, right? If it's not 100% done, and what that looks like. So what happens if you have a defective work claim after you're done with the project, right? After it's long gone and done, and then you get a defective work claim. Make sure we have good insurance, which there's an example of that next. So the plumber did, I think it was I can't even remember, it was some type of commercial building. And he did all the plumbing work, did a great job, got paid in full. Well, the building sat empty for a while, but during that time, there was some defective plumbing part burst, and flooded the whole place, and it sat that way for like a couple months, and so the whole interior had to be redone. But because he had insurance, it was covered, right? So making sure that you have insurance at the time you do these jobs, that's the important thing. It's not later on that you have insurance. It's when you do the work. The policy that you had in time when you do the work is the one that's going to cover. So making sure that you're insured when you do these work, because you never know if it's a defective part or some other defective thing is going to cause further damage, right? That'll be covered by insurance, but you have to be insured at the time of the work, right? Hugely important. Guys, it's a rough and tumble world out there in the construction industry, and it can be very painful. These disputes can be very painful anyway, but they're even more painful if you don't deal with them, if you don't deal with them properly, because you can have strikes against you right out the bat if you don't respond. And so it's hugely important to know what you're doing and how to respond properly. And I'm here for all the ideas and creative solutions to help you through this. So now we'll open it up to questions, Ms. Ayana.
All righty. So we're going to go ahead and open up the floor for Q&A. I did receive something from Courtney. There was no handout attached to the email I received earlier. There should be an Adobe PDF. If you did not get it, let me know and I can resend it to you. There are 2 emails sent out today. All righty. And at this point, if anyone would like to either pop your questions into the chat or unmute yourself, you have the floor.
Okay, I have a question. Can you hear me?
Yes, sir.
Okay, so I'm dealing with a customer and they had a water leak in the kitchen,
Mhm.
and this was a lead given to me by my son out in Austin. So I found him an attorney to fight their insurance so they get paid.
Mhm.
But down the road, we had a disagreement, and I needed more money to get stuff paid, and I didn't. I said, I wasn't going to pay for it, so now they sued me, even though I found them an attorney. So that seems like, I don't know. I just, uh, just what route should I take?
Well, I mean, obviously don't ignore the lawsuit. Did they send you a demand letter beforehand?
They sent me a demand letter. Yes, when I was about to finish the kitchen.
Okay. And so we
Mhm.
really have to dive into what they were saying in their demand letter. And don't be wrong. I mean, the money is also an issue, right? So do you have a duty to work if you're not getting paid? And obviously you don't have a duty to work and it kind of depends on what your contract says, if they're not going to promise to pay you at the end. But
Mhm.
obviously if there wasn't a time that we made a reasonable offer, you might want to do that now, depending on what they're asking for, to try to settle the matter. But if you want, Ayana, can you put Chelsea's email in there, and you can email Chelsea, and we can she'll set up a time, or Jennifer, for us to talk further and get into the specific facts.
Okay, thanks.
Mm-hmm.
And I did learn, I don't have the best contracts, and I'm learning that, I just need to get very detailed in them, I guess.
Yeah, actually, and I do a residential repair and remodel contract. If you have one, I can improve it for 1,500. If you don't have one, I do one for a flat fee of $1,750. And it's a 5 business day turnaround, and it's particularly for your business. And it sounds like, do you normally do restoration work?
Yes.
Okay.
Now,
So we
is
also
this a
add, go ahead.
is this a template, or is this something that I have to do every single time?
No, it's a template for you. Like
Oh.
we're gonna have a meeting, go over the specifics for your business and what's important to you. And like, especially if you're doing insurance work, we're gonna put some stuff in there about how, because you don't have a claim against the insurance company directly because it's not your insurance company, but
Hmm.
the owner can assign their rights in the insurance to you. So if they don't actually get paid, then you can sue the insurance company. So I mean, yes, it'll be a template for you, but designed specifically for your business and what you do.
Okay. Now, I have liability insurance, but somebody was telling me liability doesn't cover stuff like this. Is that true?
Correct. So general liability insurance generally only covers, it's not going to cover a bad work claim. There are insurances that you can buy. There's a company that you have to find an insurance company that deals specifically with guys with the construction industry. There's a company I know there. I think they're nationwide. The guy I deal with is his name is Drew. He's out of their San Antonio office. It's called IBTX, and I know that they do construction specific policies. But yeah, so like it wouldn't cover a claim for bad work or something like that. If the lawsuit had claims negligence, potentially the insurance would pick up the defense. But if it's just a straight bad work claim, then it probably won't.
Okay, and how about like on a DBA? I mean, would have made a difference if it was DBA or an LLC?
At the end of the day, it will make a difference, right? Because if they get a judgment against you and you are only a DBA, that means they can go after your personal assets. As if you were a company or an LLC or an Inc., then they could only go after the company assets. So the corporation status is to protect from liabilities for debts and liabilities of the company, which is the benefit. Now, legally, whether you're sued or not and if they win or not really doesn't matter if you're an Inc. or if you're an individual, because
A DBA.
the laws stay the
Okay.
same. It's who's liable and whose assets are up for satisfaction of any judgment if they win.
Okay.
All right, so
Alrighty, we had another question from Lewis here. Lewis says, what about dealing with defective work claims from federal work or the project manager never showed up until after demobilization? We have signed acceptance documents from the assigned representative.
yeah, I actually have one of these going on a airfield base, and
Cindy.
it depends on the terms of the contract, right? Because a lot of federal contracts have their own operating procedures and who decides the disputes. So I'd really have to see your contract to know how they handle that. And most of, like, if you're working directly for the federal government, if you sign a contract directly with them, they're going to have their own terms of how all of this plays out and who gets to decide what, right? It kind of, they're the federal government. And so if you have a subcontract, it's usually the same thing will apply. So I'd really need to see the contract to know for sure. Any other questions?
And I have included Chelsea's email in the chat here. So for anyone that might have any additional questions that you might not be able to think of right now, but want to touch base later on, please take note of that email address and reach out to us. We also have the firm's cell phone number here. You can give us a call. And I'll also be following
Yes,
it
I
up.
have one if there's time.
Yeah.
Absolutely. Good.
Okay, so I'm an LLC and I'm a residential remodeler, and I do some restoration work.
Okay.
So back history, I had a lawsuit against me last year, and where I was doing a room addition, and during the room addition, 3 major rainstorms came, and of course, it was a snowball effect where that it just, one thing led to another. At the end of the day, even though they said they loved me up until the end of trying to finish it out, before we could even begin to finish or punch list, they filed a lawsuit against me, filed against my general liability. Needless to say, between lawyers and insurance claims, I was out over $120,000. So I learned from that, and the next contract that I put in, I tried to make sure that I covered all the scenarios. My contract now stipulates that the customer cannot engage with any subcontractors, that all communication has to go directly through me, the general contractor, and that if there's any problems during construction, that they allow someone to mediate between the two situations so that there are no disagreements at the end. And I put in every roadblock possible that could be in my contract to make sure that there wasn't a problem at the end of the day. So before I could finish on this, it became apparent that they may not have enough money to pay me the last bill.
Mm-hmm.
So they've turned it into a lawsuit in which that they have put together and sent out a letter saying all these horrible things that I've done and all these promises that I didn't break. That I broke because I didn't get anything done. And even though that I bent over backwards in emails and in text, and any complaint that they had was in there fixing everything that they asked for, they were happy up until the last bill. So where I'm at right now is I've gotten this letter from an attorney, which, they're going to go full out. They want, I think the last bill was $8,000, and now they want to file against me for $36,000. And they've got mental grievances, attorney fees, all these broken promises and, things that I've done against them. So I'm kind of trying to figure out my direction, being that I'm already off one lawsuit, and which has hurt me capital-wise immensely. So I'm going through this again and trying to, based on what you had stated earlier, just kind of pay it and move on down the road.
Mm-hmm.
That kind of capital doesn't exist in my world of COVID and the recovery of COVID. And now then, with the increases of lumber, so my phone's not ringing a great deal. So I will tell you that their demand that they're looking for, $36,000, I'm out. That would be the end of my business. There's nothing left.
What state are you in?
I'm sorry?
What state are you in?
Texas, Houston.
Okay, I just want to make sure. So first off, they don't get mental anguish. They don't get all this stuff that they're asking for. But right now, Texas protects residential contractors. And so right now, this is a really good point to either, I don't know if you, so once you receive that letter, you have 25 days, I think, to request an inspection, to go view the property if you need to, and then you have 60 days to make a reasonable offer, right? And most of the disputes that I handle can get decided by that. Do you know who the law firm that sent the letter is?
Yes, he's a criminal attorney.
Okay, yeah.
He's not even familiar with any construction laws whatsoever, and that's so apparent over everything that he's got in his letter. So it's kind of, for me, it's, it's one of those things like, okay, this has to be taken seriously, but he doesn't know what he's talking about. All this being based on the suit that I just came out of. I mean, that was a year of an education I'll never forget.
I understand. And so I think, go ahead. What I was getting to is if you make the reasonable offer and they move forward and sue you anyways, and they don't get as good as that reasonable offer, they're not entitled to anything more or their attorney's fees. So
okay.
I think,
well, at first, whenever that I realized they were unhappy and that, there was nothing I was going to do, and the fact that I didn't think they could pay it, I just kind of was willing to walk away and leave the $8,000 on the table and say, okay, look, there's nothing I can do. You don't want to pay me the last check, I'll survive this and move on.
Mm-hmm.
And then this came. And I think that they just want something for nothing. And it's a ridiculous claim, because I've been over backwards in everything I've done. And believe me, I have dotted every I and crossed every T after the year that I've had. So it's kind of like, at some point, I feel like something's got to happen that is on my side. I know it's.
No, and I get it. And I think whoever's sending that letter is looking for low-hanging fruit. And if you don't answer, that's low-hanging fruit, right? So what I would do, I would hire us or hire some other attorney to do a proper RECLA response. And the reasonable offer could be, hey, guys, I did all this work. I'm not going to charge you this last $8,000 or whatever it is, or come. It just depends. I just wouldn't miss this opportunity to respond in writing to let the guy know that, hey, this is the process you have to go through, and it's not just going to haul off and file suit. and that I'm going to do what's necessary to make sure that, this doesn't happen. Because of this process, almost, I want to say, like 90% of the residential cases I handle for the contractor side end up settling.
And I understand. I do, and I get it, and I'm trying to settle this out. But at some point, when the contractor goes and he does everything that he's supposed to do, and he bends over backwards to make sure that everyone is happy, and this is still allowed. And I know I'm just spitting because I'm furious by these just seem to be the trends lately. I mean, I've been in business for 15 years and never had a problem, and these last 3, they're coming out of the network. I mean, it's just crazy. And I'm just, for me, when you've gone through years to build a business and then people are lawsuit happy all of a sudden, it's, my work hasn't changed. So
no, I understand, and it's frustrating. I do. And there's just nothing I can do to make it go away like that, right? It's not how
I know.
And even if you're 100% right, I mean, and welcome to our broken legal system.
I know. The thing before, and right after the lawsuit that I had last year, one of the customers that I had done a full home remodel for contacted my general liability company on her own after I finished, claiming that I broke her driveway. She didn't call me. She went straight to my insurance company, and that I painted her patio with bad paint. She didn't call me. She went straight to my general liability, and my general liability paid her $19,000, even though that I provided the information that, look, this is where I had pictures of everything. This is where I had the dumpster. Here's the padding I put under the dumpster. The cracks that she's pointing out to you are on the edges, and it's old concrete. Nothing. This is a false claim. They still paid it.
They're evaluating their risk, 19,000 or 100,000.
I know, but for me, because of that, they dropped me.
Well, because
I had to go out and find general liability.
Right?
I'm sorry?
Was she additionally insured?
No. Was she? No. She may have had homeowners insurance, yes. And she probably had insurance that would have covered, construction.
Because usually they don't let people file on your policy unless they're named insured.
No, my general liability did not have her named as insured.
Kind of odd. Usually the first thing is that they can't file a claim.
I know. That's what I'm saying. I feel like I can't win.
You can't catch a break. I get it.
Right. Because, if I'm having to pay out what they're on there, I literally have to close my doors. It will be the end of me. There's nothing left in capital. And I'm 62 years old, so there's not enough time to build it back.
I understand, and I'm sorry you're going through this shitty situation.
So you're saying I should respond and make an offer.
Yep. And that offer may be what you offered them originally. Hey, you guys, you actually owe me $8,000, and I'm willing to walk away from that. But not responding, he'll just sue you. If you put up some resistance.
Oh no, I'm going to respond, but I'm so leery. I want to make sure I step it. I want to step right and not wrong. Do you know what I mean?
No, absolutely. And it sounds like you probably build into your contract too. So you might want to look at those too and put those in any response letter. And as far as mental anguish and all that stuff, they're not allowed to recover that.
I was a bit dumbfounded when I saw that myself. I'm like, what about my mental anguish?
And so like there are limited cases on the civil side that allow for the recovery of mental anguish. But what I tell, like even my clients, when they want to make that claim, I said, you realize is that opens up all your medical records so that you can prove you actually suffered medical anguish, and then they get to dive in and ask you all those kind of personal questions. So is it really worth whatever dollar amount you think you're going to get?
Right.
So it's
So where did I get confused in the whole thing? It states that they have to provide me a final walk and a punch list of things, or to report to me what is wrong and give me the opportunity to do those things, to make those repairs. They didn't do that.
then they're in
I've
breach of
also put in there that yes.
And here's the other thing. Didn't you tell me your contract had a mediation provision?
Yes.
Okay, they got to do that before they can see you too. I would point all that out to the lawyer, who's probably
Yeah.
thinking
Okay.
of taking the case on contingency fee. Mediation's expensive.
Yes. Okay. Well, then I will move forward. And I'm sorry I've interrupted and taken up so much of your time.
You're good. If you want to talk further, you can email Chelsea and we can schedule a time to talk.
Okay, I will do that. I'll give someone else the floor now. I'm sorry.
No, you're good. You're absolutely good. I'm here to help everybody. I'm sure everybody's got these kind of questions, especially on the residential side. It seems when you get one pain in the ass, you get a bunch of them all at the same time. Unfortunately,
Yeah.
that's what but I think that just.
So we had Lewis, who has a couple questions. Lewis, I don't know if you're able to unmute your microphone and kind of elaborate on your question about disputes with venues.
I think I talked about the other one, which is the acceptance from an assigned representative. The venue. What about disputes about state venue? It's going to depend what the contract says, especially in your federal contracts. Most likely it will be where the project's located, but it would really depend on what the contract says. And then what is the process to collect on a judgment? Well, there's several different ways you can go about it. It depends if you know. My favorite way is if you know where their bank account is, we can do a writ of garnishment against the bank. We can get real property like real estate. We could that's not their homestead. We could get personal property like business assets, stuff like that. It all just kind of depends on who your judgment's against and what we would do. But there's a bunch of different steps. I think I have some good blog articles back in the history of on the blog articles about the different steps you could take to collect a judgment.
Awesome. Well, if that is everyone's questions, again, I will be sending out a follow-up email with website information, link to the Subcontractor Institute where you can go over that free course, and it'll also have the link to this presentation so that you could review that, and a link to the YouTube video that we will be posting later on. So be on the lookout for that. Any more questions before we close out?
Hopefully, I have a quick question.
Yes, sir. Go ahead.
Should you communicate after you get a letter, either by text or call the customer to try to settle it out?
You absolutely can. If you come to some court sort of resolution or you're going to make an offer, just follow it up with an email. But even after that point, if you get a letter from an attorney, you are free to reach out and say, hey, I really want to work on settling this. Here's what I can do. Let's talk, let's meet, and then follow that up with an email with whatever's decided. But absolutely.
Is it a good idea to talk to their attorney or not? Or are you pretty much walking into the lion's den?
That's kind of dangerous. And they may say talk to their attorney. You could try it. I've never found the attorney to opposing party successful. Attorney to attorney usually can, but unrepresented party to attorney has usually not been successful in my judgment.
Okay, and what's said on the email, let's say they say, you said you were going to do this, and you responded, well, yeah, but this and that. Is that a stickler or not?
No, I mean, as long as you respond with your reasons why, I think it's better than not responding at all. I would take item by item and respond with exactly what you need to say, and then attach any evidence, any documents, any contracts that prove your point, that prove what you're saying.
Okay. All right. Well, thank you.
No worries.
All right, folks. Well, if that will be the end of that, then we will go ahead and close out. And again, thank you so much for joining our webinars, and be on the lookout for more material that we have coming out later. All right, bye.